This brings us to the end of our exhaustive consideration of the power of search or the power to search persons. The power of search of person or the power to search persons was the fourth part of this lecture. The power of search of premises or the power to search premises is the fifth part of this lecture. Search of premises. The general rule is that without a search warrant, any search of premises is unlawful. On the other hand, if there is a search warrant, then the search of such premises is lawful. Section 37, 1999 Constitution states that the privacy of citizens, their homes, correspondence, telephone conversations, and telegraphic communications is hereby guaranteed and protected. The second general rule is that the power of search of a place, premises, also includes the power to arrest a person or persons therein. The existence of a general rule begs the existence of exceptions, and the search of premises is no different. Exceptions to that general rule exist, including 1. The omnibus exception in Section 45, subsection 1, 1999 Constitution, which states, nothing in sections 37, 38, 39, 40, and 41 of this Constitution shall invalidate any law that is reasonably justifiable in a democratic society. A. In the interest of defense, public safety, public order, public morality, or public health. Or B. For the purpose of protecting the rights and freedom of other persons. 2. The specific exception in Section 147, subsection 1, Customs and Excise Management Act, without prejudice to any other power conferred by this act, where there are reasonable grounds to suspect that anything liable to forfeiture under the customs and excise laws is kept or concealed in any building or place, any officer may, without a warrant, enter that building or place at any time, whether by day or night, and search for, seize, detain, or remove any such thing, and may, so far as is reasonably necessary for the purpose of such entry, search, seizure, detention, or removal, break open any door, window, or container, and force and remove any other impediment or obstruction. Let's recall the questions we asked at the beginning of this lecture. Does the Nigerian Customs Service have the right to track items?
Yes, they have the right to track items.
Does the Nigerian Customs Service have the right to break into a place or thing and search such a place or thing?
Yes, in trying to fulfill the obligations placed on them by the Customs and Excise Management Act.
Does the Nigerian Customs Service have the power to seal the lots of automotive car dealers?
Yes, if they suspect that they are in contravention of the Customs and Excise Management Act.
Should the Nigerian Customs Service put the car dealers on notice in respect of their intention to seal those lots as a consequence of disputed duties on those imported vehicles?
It would be nice if the Nigerian Customs Service would do so. However, if you read the law, It uses the word may without a warrant. So it is not mandatory to put a suspected offender on notice.
Does the Nigerian Customs Service have the power to close down a business premises?
Yes, if such a premises is contravening the Customs and Excise Management Act.
Is it a legal requirement to serve a notice on an establishment before searching or sealing it?
The law does not require the Customs Service to do that.
Is it a legal requirement to obtain a court injunction?
The law does not envisage the obtaining of a court injunction in advance of searching or sealing a property in contravention of the Customs and Excise Management Act.
Does the Nigerian Customs Service have the right to raid or lay siege to any property?
The law itself uses the expression any property or any place. So yes is the answer.
Does the Nigerian Customs Service have the right to block the entrance to a property?
If such blockage is in trying to fulfill the obligations placed on them by the Customs and Excise Management Act, then yes.
Does the Nigerian Customs Service have the right to impound vehicles?
Yes, they have a right to impound things that they suspect to have been in violation of the act establishing them.
Is there any property that is off limits to the Nigerian Customs Service?
The answer is no, because the act says any place.
In the exercise of their functions under the law, can the Nigerian Customs Service deprive the owner of a thing or the user of a thing the enjoyment of such a thing?
Yes, they can do so if they are trying to fulfill the functions imposed on them by the law.
Three, the specific exception in section 41, subsection 1A and B, subsection I of the National Drug Law Enforcement Act. For the purpose of this act, any police officer or customs officer or any officer of the agency involved in the enforcement of the provisions of this act may, without warrant, enter and search any land, building, or carrier, including aircraft, vehicle or container, or any other instrumentalities whatsoever which he has reason to believe is connected with the commission of an offense under this act. Four, the specific exception in section 36, subsection 1A, ICPC Act. Whenever it appears to the chairman, upon information, and after such inquiry as he shall think necessary, that there is reasonable cause to suspect that in any place there is an evidence of the commission of any offense under this act, he may, by written order, direct an officer of the commission to obtain a court order to A. Enter any premises and then search for, seize, and take possession of any book, document, or other article evidencing the commission of such offense. Section 36, subsection 2. Whenever it is necessary to do so, an officer of the commission exercising any power under subsection 1 shall obtain a warrant from a judge or magistrate to A. Break open any outer or inner door or window of any premises and enter thereto, or otherwise forcibly enter the premises and every part thereof. B. Remove by force any obstruction to such entry, search, seizure, or removal as he is empowered to effect. Or C. Detain any person found in or on any premises or in any conveyance searched under subsection 1 or until such premises or conveyance has been searched. Section 36, subsection 3. No person shall be searched under this section or under section 35 except by a person who is of the same gender as the person to be searched. Five, the specific exception in section 28, subsection 1 and 2 of the Police Act, which states as follows: a superior police officer may authorize any police officer to enter any house, shop, warehouse, or other premises in search of stolen property, search therein, and seize and secure any property he may believe to have been stolen, detain a person on the property as at the time of such seizure, or the person from whom it was taken, if different from the person on whose premises it was, and summon or arrest such a person before a magistrate to account for his possession of such property, unless previously charged with receiving stolen property. But see also section 28, subsection 3, which indicates that such power is not broad but limited and can only be exercised by a superior police officer if the premises to be searched is currently in the occupation of a person who has been convicted of receiving stolen property or of harboring thieves or any offense involving fraud or dishonesty and punishable by imprisonment, or the premises to be searched has been in the occupation of a person with, who within the preceding 12 months has been convicted of receiving stolen property or of harboring thieves or any offense involving fraud or dishonesty and punishable by imprisonment. Also see section 2, which defines a superior police officer to mean any police officer above the rank of a cadet assistant superintendent of police. Other acts containing similar provisions include NAFDAC Act, EFCC Act, Money Laundering Act, Terrorism Act, Federal Inland Revenue Act. All these acts contain provisions delegating powers to government officials to search without warrants. Search of premises provisions applying to the Administration of Criminal Justice Act jurisdiction. Section 12, subsection 1. Where a person or police officer acting under a warrant of arrest or otherwise having authority to arrest has reason to believe that the suspect to be arrested has entered into or is within any house or place, the person residing in or being in charge of the house or place shall, on demand by the police officer or person acting for the police officer, allow him free access to the house or place and afford all reasonable facilities to search the house or place for the suspect sought to be arrested. Section 12, subsection 2. Where access to a house or place cannot be obtained under subsection 1 of this section, the person or police officer may enter the house or place and search it for the suspect to be arrested, and in order to effect an entrance into the house or place, may break open any outer or inner door or window of any house or place, whether that of the suspect to be arrested or of any other person, or otherwise effect entry into such house or place, if after notification of his authority and purpose and demand of admittance duly made, he cannot obtain admittance. Section 12, subsection 3. Where the suspect to be arrested enters a house or place in the actual occupancy of another person, being a woman who by custom or religious practice does not appear in public, the person making the arrest shall, before entering the house or place, give notice to the woman that she is at liberty to withdraw, and afford her every reasonable opportunity and facility for withdrawing, and may then enter the house or place, but the notice shall not be necessary where the person making the arrest is a woman. Section 152 states, a magistrate or justice of the peace may direct a search to be conducted in his presence of any place for the search of which he is competent to issue a search warrant. Section 152 deals with the power of a magistrate or a justice of the peace to direct a search of any place in his presence that he is authorized to issue a search warrant. Search of premises provisions applying to the administration of criminal justice law jurisdiction. Section 7, subsection 1 deals with the power of search of a place entered by a person the police is attempting to arrest. That subsection actually provides for two possibilities. One, acting under a warrant of arrest. Two, otherwise having authority to arrest. Search of premises provisions applying to the Criminal Procedure Act jurisdiction. Section 7, subsection 1 deals with the power of search of a place entered by a person the police are seeking to arrest. That subsection actually provides for two possibilities. One, acting under a warrant of arrest. Two, otherwise having authority to arrest. Search of premises provisions applying to the Criminal Procedure Code jurisdiction. Section 34, subsection 1 states, if anyone who is authorized to arrest any person has reason to believe that such person has entered into or is within any place, he may enter such place and there search for the person to be arrested. Section 34, subsection 2 states, the person residing in or being in charge of such place shall on demand allow free ingress thereto and afford all reasonable facilities for search. Section 34 deals with the power of search of a place entered by a person the police is attempting to arrest. Section 77, subsection 2 states, upon complaints made on oath to a court of the abduction for any unlawful purpose or of the unlawful detention of any person, the court may, after such inquiry, if any, as it thinks necessary, make an order for the production of that person or for the immediate restoration to his parent, guardian, or other person having lawful charge of him, and may compel compliance with an order made under this subsection, using such force as may be necessary, and upon the production of the person who is the subject of the order, the court shall make such order as seems proper. Section 77, subsection 2 deals with the power of search for a person wrongly confined within a premises. By virtue of Section 78, the CPC allows for the presence of two adult citizens during search by the owner of the premises. This is not a mandatory requirement, but a desirable option at the discretion of the one whose premises is being searched. Section 85 CPC states, any justice of the peace may direct a search to be made in his presence of any place for the search of which he is competent to issue a search warrant. Section 85 deals with the power of a justice of the peace to direct a search of any place in his presence that he is authorized to issue a search warrant. In summary, the following conditions support search of premises. 1. A police officer acting under a warrant of arrest under ACJA, ACJL, and CPA. 2. Anyone who is authorized to arrest any person under the CPC. 3. A justice of the peace or magistrate under the ACJA and CPC. 4. A number of federal legislation such as Section 147, subsection 1, SEMA, Section 41, NDLEA Act, Section 36, subsection 1, ICPC Act, etc. 5. The omnibus exception in Section 45, subsection 1, 1991 Constitution. Recall the questions we asked on the power of the police. Does the Nigerian police have the power to break into a premises?
Yes, the Nigerian police has the power to break into a premises. But the Police Act only gives them that power in relation to stolen items or acts of dishonesty. It is the ACJA, the ACJL, the CPA, and the CPC that give them that power generally.
Does the Nigerian police have the power to search a premises they have broken into?
Yes, they do under the ACJA, the ACJL, the CPA, and the CPC.